Peace to the gods, peace to the gods. Yusufel here. I must say that I am very, very pleased that people were on time to class today. We got a real good show lined up today. Y'all need to be listening to this because this show is more than what you think it's going to be. It's more than the title reflects. Even if you're not a convicted felon, you should be here listening to this, because if you allow injustice to happen to one person, injustice happens to us all. And that, based off of that premise, that alone should inspire you, make you very interested in a case such as this. Once again, I want to thank the individual that sent me this case yesterday because I was not aware of it. This was like real big. There's a lot of things to discuss as it relates to this case. We're going to get into some discussions about the common law. We're going to get into some constitutional discussions as well. Let me start out by saying this, felony and possession of a firearm, anybody who's been convicted of a crime before knows that's the number one thing that usually affects you once you get a felony conviction. And it's always been my contention that the powers that be put that in, they're trying to disarm all of Americans. They don't want us having any guns. So it was a simple process for them that, okay, well, let's just make some things illegal and say if they get convicted of it, they can't have a gun. Well, how is that constitutional? It never made sense to me how you can turn an inherent right, and just because you have a felony, say I can't possess it. Always rationalize, well, they regulate commerce, and you're going to see this. This is all about commerce once again. But the judges are going to get into some common law discussion with the federal government. This is a very, very, very interesting. Let's get the likes up. Where are the likes at? Because I don't even think I'm going to start until the likes get to 100. Where the likes at right now? It's 68. Let's get the likes to 100. Y'all can at least do this. Now, I haven't read all of this case. I kind of saved it. I did a cursory examination of it, and I'm saving a lot of it to review with you. Also found the actual hearing on YouTube. So we're going to have a mixture of things. We're going to look at the video. We're going to read some court documents. We're going to do a real in-depth review of this particular case, because I think it's warranted for us to know this. Now, where we at with the likes right now? We're at 84 with the likes, so we're not ready to start yet. Okay, so let me go to, let me read the description real quick to you of this video. Read the description to you about this case. I just thought this was, this is a groundbreaking case. This is going to change a lot of things. It has not gone to the Supreme Court. Well, I can't find this is the appellate court, but I think they did a very good, how they approached it was powerful. Very powerful. Where is the, what am I looking for? Okay.
Hey guys, my name is...
Okay, let me read this to you. All right, now this is in the description of this video. And it is, in 2020, petitioner Steven Duarte was charged with the federal offense of possessing a firearm while a convicted felon. He had no violent crimes on his record. He was convicted after a trial and sentenced to be in prison for 51 months. On appeal, a panel of the Ninth Circuit reversed Duarte's conviction under the Second Amendment, holding that the government failed to show that permanently depriving Duarte of his fundamental rights is consistent with our nation's history. That's common law. Now, one of the things you're going to see in here is that not going to use that word common law. They stayed away from it because they know we looking. But when you talk about our nation's history, that's the common law. However, At the government's request, the Ninth Circuit vacated the panel's decision and agreed to review the case in banc. In banc meaning it had a panel of judges. And you're going to see this. We're going to actually see the video and listen to the discussion today. Okay? Cato filed an amicus brief, amicus a friend of the court, asking the en banc court to hold that universal lifetime disarmament of all people convicted of felonies is unconstitutional. And it is. We the people need to stand up against that, because if I've never had a violent offense. You telling me I'm deprived of my right to defend myself in a country in the most heavily armed country in the world? That somebody can break in my house and they can have a gun and I can't have one? That if somebody breaks in my house and I shoot them, then in some kind of way I got to go to prison, I'm a felon? The prison, never made sense to me. It didn't make sense to a lot of other people too. This is dangerous to freedom-loving individuals. Cato filed an amicus brief asking the en banc court to hold that universal lifetime disarmament of all people convicted of felonies is unconstitutional. The Supreme Court history-based test allowed for only narrow, concrete, historically grounded exceptions to the Second Amendment. Additionally, disarming all felony probationers reflects a judgment that all felonies are dangerous. It does. Makes sense. That premise is belied by an aggressive, decades-long trend in American politics: over-criminalization. Over-criminalization bears out a commonly held fear about the government's bid for extreme deference, that instead of tethering the Second Amendment to the dangers motivating our regulatory traditions, the government would give legislatures unreviewable power to manipulate the Second Amendment by choosing a label. And that's all they did. They call it a firearm. Remember, y'all, if you've ever watched me, they changed the label to firearm and then tried to make it something separate. You got to really get into it. They had to hide the language into this because this is a door. This is a door right here. And they know it. Exceptions to individual rights do not move with the political winds. They don't. When it comes to individual rights, history, not legislatures. History, when they say history, the common law, not legislatures, determine the existence and scope of exceptions. This means that the courts may not simply assume that the Second Amendment will expand or contract to fit any crime labeled a felony. Rather, courts must confront the reality of what modern felonies look like and compare that reality to the government's proposed historical analogs. Applying history's lessons to today's sprawling criminal codes, the court should conclude that the government has not met its burden to square universal felony disarmament with our regulatory traditions. Man, this is gonna be good. This is gonna be good. Y'all in here today? It's gonna be good. This is gonna be good. What we got in here? Common law, peace to the gods. They don't mention democracy in the Constitution. No. If anyone wants to legally sidestep the system, become a state national and get a DS-11 passport, and you are able to possess arms. Well, that's easy for you to say, Eric. Okay, that's easy for you to say, bro. Listen, Eric, I'm going to say this to you. I've been doing this 20 years, bro. I'm the one who made the passport process. I don't know why you are sitting here coming on my channel when I'm the person who put the passport process out to everyone. Didn't you get on this channel and look at the video, see how old it is? I'm the one that put out the birth certificate authentication. It was with Copper Moonshine Steels. It's been on the internet for 14 years, and they were charging people for it. I made a video, I read it, and put it on the internet. And over 500,000 people start watching it, and it spread all over the place. But if you sit here and think that just getting a passport is going to allow you to get a gun, you are sorely mistaken, my friend, and you've never been in federal custody. And that's why I do channels like this, because a lot of you come with sovereign citizen, a lot of sovereign citizen theories that haven't been tested. If you ain't never been to court before with what you're saying, you need to shut up and reserve your comments. People can only say things like that who have been to court and tested it. So let's look at this thing. This is about a convicted felon in possession of a firearm. Now, anybody been in the feds, you're probably familiar with 18 U.S.C. 922 G1. Let's look at it real quick. We're going to take this step by step. We're gonna lay a foundation and make sure that y'all got a good understanding before we listen to these judges discuss some stuff. All right, let's look at this, man. Unlawful acts, 18 U.S.C. 922. What are we looking for? Looking for G1. All right, let's get down here. Let's look at this real quick. Let's see what they talking about. Who's been convicted in any court of, let's see, restraint, who is subject to that court, fugitive from justice. They got a whole bunch of shit in here, man. This all commercial, too. It's all commercial. It's all commercial. I can't even believe they be trying to say it's not. It's like, it's so obvious. That's what they just think you stupid. They got to be operating off of, just think, oh, they stupid. He's Mikey. Tell him anything. He'll believe it. Y'all remember that Ovaltine? What is that? What was that cereal commercial? Give it to Mikey. He'll eat it. He'll eat anything. I mean, an old school commercial. Give it to Mikey. Let's see. 922 G1. Where's the fucking G at, man? Notice the transferee. Let me see. Where's G at? Unlawful acts. What is it? G. Okay, it's a little G. I was looking at the big G's. Let me look at the little G. Look at the little G's. I'm looking at the wrong letters. I'm sitting here still talking because I'm just, okay, here it is right here, G1. Okay, it shall be unlawful for any person. So first of all, we got to look at this word person. All right, we got to define that word person. That's the operative term. That is the deceptive term. That is the term that everything turns on, and we call it a person. The word person comes from the word persona. And we go back into Rome and Greece. A persona was a mask someone put on. So this is the vehicle that they use so that you can have rights in the public, okay? I guess that's a way of explaining it. It doesn't have anything to do with the republic or private rights, anything like this. Person. In the private and the republic, you're a man and a woman. You're not a person. So it shall be unlawful for any person. A person is an individual, association, partnership, company, corporation, estate, or trust. It shall be unlawful for any person who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. Now, we know that 1 year is what they have for misdemeanors. Let me give y'all some information. Okay. When you start doing this type of stuff, let me just give you the real shit, because they ain't gonna give you the real shit. If you get arrested and you try to use some of these processes as a defense and you got a strong leg to stand on, they can hold you up to a year in jail. The reason they can hold you up to a year, because up to a year, they will come and offer you a misdemeanor. They say, look, we're going to drop the felony and offer you. That's what they do. They can't get you, so they'll try to drop it to a misdemeanor. So they can hold you up to a year. You need now put what I just said in your pocket. You can listen to these people talk about their passports and all that. This is experience talking. This ain't coming from Boo Boo Bay. All right. Number 3, who is an unlawful user of or addicted to any controlled substance as defined in Section 102 of the Controlled Substance Act. Who has been adjudicated as a mental defective, who has been committed to a mental institution, who being an alien is illegally or unlawfully in the United States, or except as provided in subsection Y2, has been admitted to the United States under a non-immigrant visa, as the term is defined in Section 101A26 of the Immigration and Nationalization Act, 8 U.S.C. 1101A26, who has been discharged from the armed forces under dishonorable conditions, what? Who having been a citizen of the United States has renounced his citizenship, who is subject to a court order that A, was issued after a hearing. Let me see, what is this? Let me see, go ahead. Convicted in a court of a misdemeanor crime of domestic violence. To ship, okay, there it goes right there. Who has been convicted in any court of a misdemeanor crime of domestic violence, and here it is. To ship or transport, this it right here. Look at the word commerce. To ship or transport in interstate or foreign commerce. I read so many indictments, I don't even understand why y'all would argue with me about this. It's about the Commerce Clause. The Fed's whole jurisdiction revolves around Article 1, Section 8, Clause 3, Article 1, Section 8, Clause 9, and Article 1, Section 8, Clause 17. That's their jurisdiction. Fuck all that other shit them gurus is telling you. Take it from me, I was in there. It starts with the Commerce Clause. Everything they doing is commercial in nature. That's why you have a 27 USC 72.11. To ship or transport in interstate or foreign commerce, or possess in or affecting commerce, possessing commerce or affecting commerce, which means they have to be directly tied to commerce. If it indirectly affects commerce, interstate commerce, any firearm or ammunition, semicolon, or to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce. Why y'all can't read this and see what this is talking about? I don't understand it, how niggas is in jail and they ain't read this shit and what the fuck is this commerce, this interstate commerce? I was in there. These niggas be in the law library 20 years reading this shit, jumping right over that interstate commerce. That's the first thing I saw when I read my first indictment. I said, damn, what is this? Because I read the Constitution. And then I said, what is this interstate commerce thing? When that sheriff came to me and he told me, he said, Jones, you always talking about the Constitution. I bet you ain't even read it. It's my contention that if you ain't never read the Constitution and you don't know the difference between a democracy and a republic, your ass should not be allowed to vote. I'm talking to all you Democrats out there. That is why your mascot is a goddamn jackass. And ours is an elephant, which stands for intelligence and being conservative. An elephant never forgets. Elephant, one of the most intelligent mammals on the planet, outside of a whale and dolphins. Let me get back. All right, so we read that. We got some idea. It said 99.9% do not fathom what commoner entails, including use of. Let me put it like this. I'm light years ahead of you. You're not even in my league. You shouldn't even be. I ought to fucking kick you out. Hey, let me put you on quiet time. Don't disrespect me, man. Don't disrespect me, man. Let me put you in timeout. You sitting here, you fucking with the wrong dude, man. Don't disrespect me, man. Keep your ass out this chat. Talking about what I don't know. I can't fathom. You can't fathom that you fucking with the wrong person. Keep it flowing with that high frequency I am. Settlement and set off. Okay, so let's keep going. I had to put them in timeout. All right. Anyway, so we're talking about commerce. Okay, so we got that. We got that down. I know y'all just joining me. So we just read 18 USC 922 G1. Okay, they cannot. They shipping something in foreign commerce is what we're talking about. Commerce. Okay, so what next? All right. Let's read what these people are saying before we go into further into the discussion. All right, so I'm going to, and there's two cases actually we're going to look. We're going to read the summary of USA versus Duarte. So let's read that first, and let's get some context before we listen to what these judges are discussing. All right, let's get into it. Let's read the summary real quick. Summary. USA versus Duarte. So we're reversing the district court's judgment. The panel vacated Steven Duarte's conviction for violating 18 U.S.C. 922 G1, which makes it a crime for any person to possess a firearm if he has been convicted of an offense punishable by imprisonment for a term exceeding 1 year. On appeal, Duarte challenged his conviction on Second Amendment grounds, which the panel reviewed de novo. The word de novo means anew. And what it means is they're not looking just at the procedural errors in the case. They're kind of looking at the whole case over again, almost like they're retrying the case on the appellate level, which is what they usually don't do. They usually just review it for reversible error. So plug that word de novo into your vocabulary because you will see it a lot when you are reading case law. This word de novo, it means anew. Rather than for plain error because Duarte had good cause for not raising the claim in the district court when United States versus Vange. And now we need to also, this is volume 594, Federal Reporter, 3rd edition. And this is page 1111. The Ninth Circuit in the year was 2010. Please learn how to read a citation of authority and go into the law library and practice pulling those books off the shelf. I hate it when somebody read United States versus Valgray, 594 F 3D 111, Ninth Circuit 2010. I'm going to make y'all take y'all game to another level. I'm going to shame you. Take your game to another level. Learn how to read citations of authority. And there's a lot of them. I'm not saying you're going to have all of them by memory, but at least know how to, if you know what the, what the letters stand for. Like this right here is like U.S. Reporter right here. This is volume. The first numbers is the volume. This is volume 597. Let me see if I can pull this up and show y'all what I'm talking about. These are volumes. I think it's U.S. Reporter. Where is that? Wait a minute, let me see. U.S. Report. Let me see if I can take this 597 off. This pop up. U.S. Report. See, this is right here. It look like this right here. See? These numbers tell you what book you're going to pull off the shelf. All right? And then it tells you what page to go to. It tells you the volume, the type, the set of books that it is in, and then the page number it's on, and the date the decision was made. So get in the habit of looking these up. Okay? Peace. Appreciate the 1999 Masters of Ceremony. I appreciate that. So, now we're going to pull these cases to this. I haven't got a chance to read Vange, United States versus Vange. All right, let me pull it up. I think I downloaded it because you want to read every case associated with this. You don't want to half step at all. You want to read the background story of it. All right, here, that's the case text. Here it is right here. Ninth Circuit Court of Appeals. Yeah, Peter Vange. Yeah, this is appealing a felony in conviction too. It's another case. So we're going to read all these cases, all right? But right now, we concentrated on this one. Duarte had good cause for not raising the claim in the district court when United States versus Vangre foreclosed the argument. So he must have lost and ruled against him, so he didn't think he could raise the argument in the U.S. District Court. So I'm not sure how they got it to the appellate court and were able to raise it, but the appellate court decided to do an banc review, de novo review of it, and I'm just interesting. Why we're gonna look at the case and see how they came to that decision. So the panel held under New York State Rifle and Pistol Association versus Bruen. Okay, 922G1 violates the Second Amendment as applied to Duarte, a nonviolent offender who has served his time in prison and re-entered society, and that Vangre did not apply the mode of analysis that Bruen later established and that requires courts to perform is clearly irreconcilable with Bruen. I love that. I love that. Applying Bruen's two-step text and history framework, the panel concluded, number one, Duarte's weapon, a handgun, is an arm within the meaning of the Second Amendment text. I like that because I was under this notion that since they converted everything to commercial items, that's why they call it a firearm, and they excluded it from the definition under the Second Amendment. But it looks like, I don't know if it's the appellate court or the Supreme Court seems to take issue with that. Right here, I think this is appellate court. Was it appellate court? Van Buren, is this appellate court? Yeah, it's Court of Appeals, appellate court. All right. Duarte's weapon, a handgun, is an arm within the meaning of the Second Amendment text that Duarte's proposed course of conduct, carrying a handgun publicly for self-defense, falls within the Second Amendment's plain language, and that Duarte is part of the people whom the Second Amendment protects because he's an American citizen. Now, I like this right here, as opposed to somebody telling me to get you a passport and carry a gun. Do you understand how much time you can get if you're a convicted felon and they catch you with a gun and your theory doesn't work? This is how you study and you get you something to stand on. Because right here, the judges are doing their job. So let's keep going. Mr. Judge M. Smith. Let me look at this dude. Judge M. Smith dissented. I wanted to look him up. Let me see who Judge M. Smith is. I want to look this dude up. Who is Judge Mullane Smith? Is this him? Judge Mullane Smith? To the Ninth Circuit. Yeah, that's him right there, Ninth Circuit. Y'all seeing this? This is what I want to do because I want to see why he dissented. I want to know what his political position is, and I want to know his nationality. This is how you find out who your traitors are. Why y'all can't seem to, y'all call everybody a white man. You think it's the white man. I can't stand for doing that. They blame everything for the white man. You sound so weak and intellectually inferior when you keep blaming the white man for everything. So it was confirmed May 16, 2006 to the Ninth Circuit, which hears appeals from the federal district courts of Alaska, Arizona, California, and Guam, Hawaii, Idaho, Montana, Nevada, Oregon, and Washington. Judge Smith has a distinguished record as a practicing attorney in the public and private sectors. Hold on, let me pull this dude up. Say Judge Mullane Smith is him right here. Brigham Young University. Okay, that means he might be, he's out there in the Mormon territory. That's interesting. He went to Brigham Young. After law school, federal justice. Let's see. I'm trying to find out his family life, and this is how I usually find out their nationality. Let's see. Fourth Amendment. Let me see. Second Amendment. United States. Smith, writing for a unanimous 3-judge panel, upheld a conviction for the possession of a homemade machine gun. Remember we were talking about making your own guns? Rejecting the defendant's Second Amendment claim based on the District of Columbia versus Heller. Smith wrote that machine guns are dangerous and unusual weapons that are not typically possessed by law-abiding citizens for lawful purposes, and that their possession is not protected by the Second Amendment. Oh, really? And now we have right here, USA versus Duarte. Smith dissented from the majority opinion, which held that the felon in possession statute violates the Second Amendment as applied. So we know his position. He don't want you to have a gun. This is what we got to know when we confirm these people to the U.S. Supreme Court, because it's appellate court. He's not getting my vote for the U.S. Supreme Court. Now, he might get some of these bleeding heart liberals who want to disarm everybody every time there's a school shooting. But guns don't kill people, people kill people. And the reason the United States of America has never been invaded by a foreign country, because we're the most heavily armed citizens on planet Earth. And I like it that way. So we know who this cat is right here. Now all I have to do is find out his nationality. I don't know what his nationality is. Let me see. Mullane Smith, Court of Appeals. Smith's brother, Gordon H. Smith, was a Republican U.S. Senator. Mullane Smith is neither Republican nor Democrat. He considers himself to be a political independent. Smith was born in Pendleton, Oregon. He is the son of Mullane D. Smith, who served as Chief of Staff of the Department of Agriculture under Secretary Ezra Taft. Smith has a Bachelor of Arts degree from Brigham Young University. He attended Chicago Law School of a full tuition scholarship, graduated in 1969 with a Juris Doctor. Okay. All right, they told me a little bit about him. I'm gonna leave it alone. I'm gonna research on him. I ain't got everything that I need, but I want to know who this judge is who dissented. He's the lone dissenter of this decision. It just ain't right. If you convicted of a felony, you can't never have a gun ever. And if I catch you with one, you do you know that convicting felon in possession of a firearm, just getting caught with that, used to give you 10 years in the Fed and sometimes 15, depending on what it was? Y'all don't understand how draconian these laws are and why I'm reviewing it, how important it is for you to understand this case and these decisions. Oh, somebody say they don't like prepositional phrases. We gonna the syntax. We got some followers of David Wynn Miller in there. But okay, let's go. He said he wrote. So let's go. Counsel. Okay, we already know who counsel was. Opinion. Circuit Judge, 18 U.S.C. 922 G1 makes it a crime for any person to possess a firearm if he's been convicted of an offense punishable by imprisonment for a term exceeding 1 year. Steven Duarte, who has 5 prior nonviolent state criminal convictions, all punishable for more than a year. He had 5 felonies, but they were nonviolent. Now, how many of y'all out there got felony convictions that are nonviolent? This is why you look up case law to see a precedent and find someone who has the same situation as you, and you can cite it, because the courts have to stay consistent in their determinations. Usually when they all start ruling differently in different jurisdictions, that's why the Supreme Court will grant certiorari to make everything consistent. That's their job. Keep everything consistent. If there's confusion on the district and appellate courts, they'll tell you, hey, look, we're going to clear it up for you. This is how it needs to roll. Interesting to see if this makes it to the Supreme Court, because these are appellate court decisions, which to me seem to be well-drafted opinions. So, Steven Duarte, who has had 5 prior nonviolent state criminal convictions, all punishable for more than a year, was charged and convicted under 922G1 after police saw him toss a handgun out of a window of a moving car. Duarte now challenges the constitutionality of his conviction. He argues that, under the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruen, oh, it looks like they already did get it. Let's pull this up. New York, this is a Supreme Court decision. Okay, so he was already watching. He found a decision come down, and it's okay. I see it. Let me pull this up. Yeah. Okay, here it is right here. New York, Bruen. Let's see. This is right here in the Supreme Court of the United States. Is this it? Injunction. No, that ain't it. Oh no, this is it right here. But is that? No, that's not it. Wait a moment. Is this it? Is this the case? This is the case text. Let me see if I can download it as a PDF. They want me to. Okay, all right. Okay, so here it is right here. New York State Rifle and Pistol Association. Paul D. Clement. The cause for petitioners with him on the brief was Aaron Murphy. Okay, they gave certiorari to the United States Court of Appeals of the Second Circuit. Paul D. Clement argued the cause for petitioners. Where is it at? Where's the brief at? Where's the summary? Because I don't understand how New York prevents y'all from having guns in the city of New York. That's unconstitutional. It's unconstitutional. I tell you, you can't have a gun in the state of New York. That's crazy. Let me see. Let's see. Where is that it? New York State has regulated the public carry of handguns at least since the early 20th century. In 1905, New York made it a misdemeanor for anyone over the age of 16 to have or carry concealed upon his person in any city or village of New York any pistol, revolver, or other firearm without a written license issued to him by a police magistrate. In 1911, New York Sullivan law expanded the state's criminal prohibition to the possession of all handguns, concealed or otherwise, without a government-issued license. Okay? Today's licensing scheme largely tracks that of the early 1900s. It is a crime in New York to possess any firearm without a license, whether inside or outside the home, punishable by up to 4 years in prison or a $5,000 fine for a felony offense and 1 year in prison or a $1,000 fine for a misdemeanor. Meanwhile, possessing a loaded firearm outside one's home or place of business without a license is a felony punishable by up to 15 years in prison. That's what I'm telling you. They was doing the same thing on the feds. Okay, we see that case. I'm going to come back to that. All right? All right, so it goes on. It says, we reject the government's position that our pre-Bruen decision in the United States versus Von Gray forecloses Duarte's Second Amendment challenge. Von Gray is clearly irreconcilable with Bruen and therefore no longer controls because Von Gray held that 922G1 comported with the Second Amendment without applying the mode of analysis that Bruen later established and now requires courts to perform. They didn't have the same analysis used in that earlier case. Bruen instructs us to assess all Second Amendment challenges through the dual lens of text and history, common law. If the Second Amendment's plain text protects the person, his arm, and his proposed course of conduct, it then becomes the government's burden to prove that the challenged law, and this is why you challenge their laws, because they pass laws all the time unconstitutional. It's up to us, we the people, to challenge the constitutionality of that bullshit they be passing in the state and federal legislatures. We got to watch who we send up there on Capitol. We done let a lot of weak girly boys up there passing laws. That's why your child support laws are so ridiculous. Y'all letting these girly boys up there. A man can be a woman, a man can have a baby. Gotta get their ass up out. Get their ass up them office, get them out them seats. Amendment's plain text protects the person, his arm, and his proposed course of conduct. It then becomes the government's burden. The burden of proof is on he who asserts, not he who denies, to prove that the challenged law is consistent with the nation's historical tradition of firearm regulation. Van Gay did not apply these two analytical steps because Bruen had not yet established them. We must therefore reconsider 922G1's constitutionality, this time applying Bruen's two-step text and history framework. Beautiful. All right, before we go on, let's look at the argument now. Let's look at what the courts were saying. I think we got a good foundation. We got some good context now that we can spring from, and now we can listen to the discussion with understanding. All right? So let's get to the case.
Anderson for the appellant, Steven Duarte. I plan to reserve 3 minutes for rebuttal. I'll watch my clock. There are approximately 20 million Americans with prior felony convictions, many of whom have committed no violent acts. This is a case about whether the government can, consistent with Bruen, permanently strip gun rights from those many prior felons with only nonviolent convictions, without showing that the founders permanently deprived nonviolent prior offenders of the right to bear arms, or otherwise imposed a similar burden on gun rights for a similar reason. In my time today, I want to address 3 things. First, I want to talk about how broad the power the government is claiming to disarm anyone it deems untrustworthy, non-law-abiding, or irresponsible is, and how that would eviscerate the Second Amendment right and return us to a regime of deference to legislative decision-making.
Counsel, before you do that, I'm really interested in your position in light of the concurrence that Justice Kavanaugh and the Chief Justice handed down in Bruen. As you know, I think, they referred back to Heller, and they said, let me make sure I get the right quote here, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons. Right?
Yes, Your Honor.
So they're kidding, right? They just meant non-violent felons.
It's not that they're kidding, Your Honor. It's that's a concurrence. It's not the majority opinion. The majority.
But they joined in the majority. Without them, there would be no majority.
I understand, but someone concurring doesn't have the right to.
How about Justice Alito, who said the same thing, basically?
I'm not sure he said the same thing, but as it is, the main opinion of Bruen holds that there's one constitutional test for Second Amendment questions, and that is plain text and history. So the main opinion says.
But with respect, at least from my perspective, this is a 2-part analysis. The first part is who's covered.
Right.
The second part is in what way, and what firearms, etc. The first part is who's covered. And as I look at our earlier case, as John's saying, I know you take an exception, I want to get your view on that. Felons are excluded. They're just excluded. And that's Justice Kavanaugh, the Chief Justice, Justice Alito, Justice Amy Coney Barrett. They were necessary to the majority, and all of them, they don't use non-violent felon. They say felon, because anciently, historically, that's the way it was. So how do we get around that?
Again, by looking at the main opinion. I mean, people opining about how a text and a text and historical analysis might come out is different from actually performing the text and historical analysis.
But with respect, and because we don't have a lot of time, that's why I'm asking these questions now. There were 14 mentions in Bruen about the 14th Amendment only applying to law-abiding citizens. What does that mean?
It's 14 mentions of law-abiding and responsible, or some combination of law-abiding and responsible. It's not saying it only applies there. In that language comes from Heller, and in Heller it's used to talk about what an easy case that is, right? They go and they define people, and you're talking about who's in the text and who's out. They define people first, and they define that very broadly. Mm-hmm. All Americans, all members of the national community. Mr. Duarte, despite being a felon, is still an American.
Okay,
He's a member of the national community.
Well, that if you have 10 convicted murderers, all of whom are American citizens, that they're entitled in jail to a Second Amendment right?
In jail?
Yeah.
I think you'd get around.
Careful.
Sorry? I think you'd get around in jail by custody and by historical practice. I'm sure at the time of the founding, people who were in jail were not allowed to have weapons.
And felons go to jail sometimes, don't they?
Right, so when they're in jail. We're talking about people who are.
You're saying that only when they're in jail?
I'm saying I am sure there is a historical antecedent for taking weapons from people while they're in jail. I don't see a historical antecedent for keeping weapons from them once they've been restored to their freedom.
Well, on the Zhangse case, the argument that you make is one that was made in a case called United States versus Phillips. And Phillips concluded that our Miller versus Gammy did not apply because they did not use the two-step analysis. They knew about Heller and applied it to individuals. Why does Phillips not say that Zhangse applies in and controls this case?
Because of Bruen, Your Honor. Bruen clarified the Second Amendment analysis. Bruen comes in and it says, basically all of the lower courts are misreading Heller.
Now, Bruen, in the first sentence, says, as set forth in the pleadings below, petitioners Koch and Nash are law-abiding adult citizens of Rensselaer County. How do you define law-abiding?
I mean, I don't, Your Honor. I don't think that's the constitutional limit. I think that the court is describing these people as being law-abiding and responsible because they're saying this is an easy case. The way they use this in Heller is to say, we don't have to get into levels of scrutiny. We don't have to get into all of this because this is such an easy case.
Definition of law-abiding, don't we?
Sorry?
But it's a qualification. All adult citizens are law-abiding adult citizens.
All law-abiding, but again, the main opinion of Bruen is that you need to look at text and you need to look at plain text, you need to look at history, and there is no plain text analysis that limits the Second Amendment to law-abiding rights. If you look at the text.
Okay, counsel, with respect, I don't think you've read Heller either, because they both talk about law-abiding citizens.
Yes, Your Honor, they do talk about law-abiding citizens in Heller, but it's as I was trying to say, they define people, and they define people broadly, and then when they get
they refer to all Americans twice in Bruen, but 14 times law-abiding. So again, there seems to be a contradiction here.
I don't see a contradiction, Your Honor. Again, when Heller explicitly defines the people, and it doesn't define the people as only law-abiding responsible citizens. It defines the people as all Americans. When it goes on to talk about law-abiding and responsible citizens, it's when it's answering the dissent. The dissent says, how can you do this? How can you do this without telling us about levels of scrutiny? And how come you're not giving us a more fulsome explanation of how the Second Amendment works?
Did not do level of scrutiny.
Sorry?
Youngse did not use a level of scrutiny.
No.
A two-step process. Referred to Heller, said that nonviolent felons were not covered by the Second Amendment. That's our binding precedent. Phillips says it is. Unless Miller versus Gammy allows you to overrule it, it controls this case, does it not?
Yes, but I believe under Bruen it's overruled because Bruen's.
The Miller versus Gammy analysis.
That is
so
Miller.
Tell me what in Bruen says that our case is overruled. It's just inconceivable that it can continue to have any viability in light of Bruen.
Miller v. Gammy says that precedent whose mode of analysis is clearly irreconcilable with intervening Supreme Court case law is overruled.
And in what way is it irreconcilable?
So Bruen says there's one single analysis for the Second Amendment, plain text and history. It doesn't say there are two analyses. One is, does it show up on our list of presumptively lawful, or show up on the list of presumptively lawful regulations from Heller? And if it doesn't, then we do text and history. It says text and history. And even in Heller, the court's saying, these are, we're not explaining why we think these things are presumptively lawful now. We'll do that when the case comes before it. And that.
But you're skipping to the second prong, in my opinion.
Okay.
You've got to define who's covered. I don't see how you get from Bruen, where you have 4 justices that were essential to the majority, all saying that felons are covered. They're all covered, and they're not law-abiding citizens. 14 times they refer to that. And so if, just arguendo for a moment, okay? If that's correct, then there's no problem, right? They're just, your client's just not covered.
If it's correct, I'm sorry, I missed which part, if which part is correct.
Well, that law-abiding citizens are the only ones covered by the Second Amendment. They assume that. And then, and earlier in Heller, they talk about felons. So how do we get around that?
Again, because Bruen is saying you have to do text and you have to do history, and nobody has done that. You're talking about who's covered, first step, plain text. Nobody has done a plain text analysis that says felons are not covered.
The Supreme Court did, in the sense that they said it's covering law-abiding citizens.
But
The boss, they decide.
They use the phrasing law-abiding citizens, but when it comes to the who of the Second Amendment, the operative clause of the Second Amendment, you know, the rights of the people to keep and bear arms shall not be infringed. The who is the people. And they plainly define the people, explicitly define the people.
But they accept out felons.
Yeah, but they say, they presume, but that's a prediction about a textual or historical analysis that they haven't done yet, Your Honor.
Let me ask you this, and then I'm talking a lot here, but it's an important case.
Yep.
If the Bruen case and the Heller case do not overrule Shaanxi, it controls and you lose, right?
If Banc is not overruled, then yes, it controls. I agree with that. I want to hold on to some of my time, but I do just want to speak briefly about how broad a power the government is claiming. It does go to this law-abiding and responsible limit. I mean, if that's the limit, there's nothing in law-abiding that would limit us to felons as opposed to misdemeanants, as opposed to scofflaws who litter, speed. There's nothing in irresponsible that limits us to lawbreakers at all. I mean, taking on huge amounts of debt, that could be considered irresponsible. Being habitually late is irresponsible. And so if that's the constitutional limit, that leaves a lot of room for a motivated legislature, let's say the California Assembly, to start taking gun rights from people if they decide that that's what the most important thing is. And even the felon thing leaves the motivated legislature with a lot to work with. As it came up in Range, this idea that the government was asked, if the legislature made lawn mowing a felony, if the legislature makes jaywalking a felony, can we take those people's guns away? And the government says, because their rule is felons, yes. And so that's very problematic. It leaves a lot of room to impose on the Second Amendment and leaves us back with the legislature being the one who's deciding who has a Second Amendment right. And I'll reserve the rest.
Very well. Morning.
Good morning. Good morning, Your Honor. Saria Bahadu on behalf of the United States, and may it please the Court. The question before this Court is whether banc remains good law, and it does. Bruen instructed courts to look at Heller, to apply Heller, and to apply the history and tradition test in Heller. That is what banc does. Bruen also instructed courts to not apply means and scrutiny. Banc followed that instruction too. In our view, the simplest path in this case is to hold that Bruen is not clearly irreconcilable with banc, and that banc continues to apply categorically to felons, nonviolent or otherwise.
We were told in Heller that nothing in our opinion, that's in the court's opinion, should be taken to cast doubt on long-standing prohibitions of possession of firearms by felons. What are your long-standing prohibitions of firearms by felons in the historical tradition that you put forward to limit the text of the Second Amendment as applied to this individual?
The text of the Second Amendment?
Yes.
As applied?
To keep and bear arms.
Yes, Your Honor.
If, as I understand Bruen, once the conduct fits within the Second Amendment to keep and bear arms, then the burden becomes the government's to show that there's a historical tradition of long-standing prohibitions on possession of firearms.
That's correct, Your Honor.
Where are your long-standing prohibition on bearing firearms by felons?
The long-standing prohibitions date back to England, Your Honor. In our brief, we talk about...
In the Statute of Northampton?
No, not the Statute of Northampton, right, which is going armed to terrorize a community. And I think there's actually the Statute of Northampton from 1328. But in our brief, we really talk about two categories of laws that we think aptly support 922G1. The first category of laws are laws imposing capital punishment on felons and forfeiture on felons. And the laws imposing capital punishment date back to England, right? Blackstone, which courts, especially members of this court, have cited in a concurrence in Chauvin as well as a dissental in Mai, have relied on Blackstone and its commentaries that in England the penalty for a felony was death. And so just going from...
Let me ask you about that a little bit.
Yes, Your Honor.
At the very end, I think of, he talked about range. And in range, I think, if I'm right, they asked the government's counsel, well, why couldn't California, they probably didn't use California, they used their version of California. Why can't California just say jaywalking is a felony, punished by a year and a day, of which will make a year and a day go away somehow.
Sure.
And then take away everybody's gun rights. So why couldn't you do that?
Well, I
Let
think...
me ask you this. Do you think if they made jaywalking a felony, could you say that person couldn't have?
Well, in our view, we think history and tradition support disarming felons because they have committed serious crimes.
That's not an answer to my
well,
question.
Right,
And
I'm going to get there. I'm going to get there.
This
Yes.
is really important. People ask me all the time, now that you're a judge, what do you care? And it's whether advocates, let's answer your question. You're not answering my question because it's a hard question. So so the question is, think of the hardest, the person, your best friend, who's an angel, and that whatever that person does, tears a tag off a mattress, suddenly that's a felony. Can that person, can they ban that person? And I think in range, the government's, and so I assume that you want to be consistent. So is your answer yes or no?
In our view, if a legislature has labeled a crime a felony, then we do think that there's a history and tradition for disarming.
Good. That's right. I mean,
but
that's good because now we understand. So then that really brings to light the question of, even assuming there was, and I think it's actually a hard question, whether there's a longstanding tradition for felons across, because you don't actually have any longstanding bans on felons. You have bans on other things. You have putting felons to death, but you don't have actually gun bans on felons. But let's just pretend there was. Let's say there was you had tons of evidence of actual legislatures at the time of the founding banning felons. But there was no examples of tearing a tag off a mattress as being a felony. Do you see the problem there? The problem is if you can, now the legislature can just basically say anything they want as a felony and they can bypass a constitutional right. It's just like you could say, there's been a longstanding understanding that fighting words were not, and so now we're going to say that any political speech by pick your party is a fighting word. Mm-hmm. And now all of a sudden the First Amendment goes away. So what is your answer to that problem?
The limiting principle I think is the question, and there are limitations on legislatures, and I can name a few.
Tearing a mattress sounds like it's pretty far down the slippery slope. Trying to take off a mattress.
Well, I can name at least a few limiting principles that I think would apply to legislatures, that this parade of horribles simply would not occur. The first is that there are constitutional limitations, right? Legislatures cannot over-criminalize because other constitutional provisions would have something to say about it. That's the Due Process Clause, that's the Equal Protection Clause, that's also the Eighth Amendment.
What you're saying is, I think there may be a constitutional limit to the fact that they wouldn't be able to make tearing a tag off a mattress punishable by a year, something else, like cruel and unusual or something, right? But Second Amendment wouldn't speak to that, but it's possible that they couldn't make tearing a tag off a mattress a felony for some other constitution. Is that your argument? Just make sure I understand.
Well, I do think that the Second Amendment would have inherent limitations as well, because we know, for example, that the Second Amendment does. The point of the Second Amendment is not to disarm broad swaths of the American people. But I did want to speak to inherent limitations apart from the Second Amendment, because I understood the Honor's question to say, putting aside if we don't have exact historical analogs, what is going to keep a legislature in check? And so we do think the Second Amendment does keep the legislature in check now, thanks to Bruen, which has returned us back to Heller, because it's...
But to be clear, I think what you're saying is it keeps the legislature in check in the sense of anybody they want to disarm, they have to now label a felon.
No, I don't think that's correct. I don't think that's correct. I don't think that, for example, 922G has been a part of this country's history since at least 1938. That was its original form, and now we are in the amended form, I think, was in the 1960s. So for this amount of time, we've had legislatures operating under whether or not they could label something a felony, and they would have knowledge that that would then trigger 922G1.
But what they have labeled as a felony since the 1930s is very different than what they labeled a felony at the founding. And so are you saying that they could change from the founding to the 30s? You know, now we can have felonies for like literally filling. I mean, I think they had some fun ones in the briefs, some real ones other than tearing out, but things that seem like they certainly wouldn't have been felonies at the founding. But you're saying we're stuck with what we had in the 30s? I don't think you're saying that. So
no. I want to acknowledge that there's a bigger number of felonies than there were in 1791. And we look to 1791 for the principles that would essentially restrain legislatures. I do think that there are principles in the Second Amendment.
You don't have much time, so you're speaking kind of vaguely that I think there's some restraints, but you got to realize, like, I'm actually trying to say, as a practical matter, it doesn't sound like there's very much, because going back to what you first conceded, which is, listen, if you want to make tearing a tag off a mattress, if legislature wants to make tearing a tag off a mattress, then we think that would make that a felony. Then the Second Amendment doesn't prohibit it. But you're speaking about limitations, like, you know, in some vague abstract terms, but that doesn't sound like much of a limitation.
Well, I can give a few more. So I mentioned the constitutional limitations. I also think that there's the political process. Legislatures are proxy for their people, and we have seen time and time again.
So I understand that argument. Of course, you could say the same argument about the First Amendment. You could say First Amendment protects, and when the legislature says that you shouldn't be able to, you know, do X or Y, say X or Y, it's been through the political process. Okay, so I get both of your arguments. I'm not hearing much. That sounds like the type of any other right that we would think, like the Fourth Amendment or the First Amendment, those arguments would never fly for those. So
I mean, those amendments, though, have their own restrictions with respect to felons in particular, too. I mean, under the Fourth Amendment, right, we have felons who are subject to probation. They have lesser rights than the broader swaths of the community. We have felons who are subject to PCRS, which is a very strict form of supervision. I think even under the First Amendment, we do have some felons who are actually subject to lifetime supervised release, and they will have their First Amendment rights curtailed.
Can I get back for a second? I know my colleague is a real expert in this and wants to go these historical things, but I just want to make sure I understand the government's perspective on one thing. I gather that you contend that Yonsei controls in this case, that Phillips backs that up, and the only way it gets overruled is if we have an en banc court that changes it. Is that correct?
Yes, correct in part. Vacated remains controlling precedent, but I would say that Bruen does not render vacated. Bruen is not clearly irreconcilable. So I even think
that's my point.
Right.
In other words, it's the government's position that Yonsei is not clearly irreconcilable with either Heller or Bruen, and if that's the case, the only way Yonsei can be overturned, because it covers nonviolent felons, is to have an en banc court. We can't do it as a three-judge panel. Is that your position?
That's our position. And I just want to say that if this case did go en banc, we would again be relying on Bruen to say that this court's precedent has been in line with Bruen as well as Heller.
Two-part argument is Bruen hasn't abrogated our precedent, and even if it somehow had, you win anyway.
Right, because I do think that...
Can I take you back to Judge Smith's? Because
absolutely.
The challenge with that position is Vacated relied on, what was the case that Vacated relied on? That
it relied on Everest, Well, it relied on Younger, it relied on Emerist.
Wrote the decision.
It relied
So,
on a couple of cases,
So
actually.
Younger was so Vacated clearly relied on Younger and literally said that Heller has not abrogated Younger. And so the thing we're saying is binding has gone through two iterations of pretty serious Supreme Court changes. One is Heller, which said not a collective right, but it's an individual right, whereas Younger said it was a collective right. And then there was Bruen, which said, yeah, two steps. It's not a two-step thing. You got to look at history and tradition, period. So those are pretty significant changes. Everybody, I think, recognizes that. And yet you're saying that a decision, really it's not Vacated, it's Younger, because Vacated relies very heavily on Younger. That Younger, that predates both those very serious, so that still just binds clear through. That just sounds like, well, what does the Supreme Court have to do? Does it have to like literally name Vacated or Younger by name in its decision to abrogate them?
Okay, can I join in this question?
Sure.
Because I think we both have the same issue. The Phillips case analyzed the very thing that he's talking about, where Heller had been decided, the argument was made by learned counsel for the defense that Heller overruled it because of reliance on Younger. They said, no, that's not true. If you're going to change it, you've got to have an en banc. So, at least for our court's purposes, the Younger aspect is not going to change anything. The question is whether Bruen perhaps changed it. What's the government's position on that?
So I think I have 2 points that I do want to make. So in Vacated, it did point to Younger, but it explained that when it was saying that it was bound by Younger, it cited In re Osborne, which explained that this court is bound by holdings, not reasoning. And then the second thing that I did want to say as well is that Vacated did not just rely on Younger.
What does that mean? I read that.
I think that
So, because the problem with that is, does that mean that the Supreme Court has to have precisely a nonviolent felon case? Otherwise, we're just bound. It doesn't matter how much its decision. Let's say it completely undermines. I know you're not conceding this, but completely undermines the reasoning. But it's not a nonviolent felon case. It has to be a nonviolent felon case?
I mean, it has to be clearly irreconcilable, and I think this court has gone so far as to say it has to compel a different conclusion.
Well,
to be
let's say the
clearly
rationale
irreconcilable.
is completely irreconcilable, but the holding is not, because it's not a nonviolent felon case. So that's what I'm trying to get at. It's like, if the rationale, let's assume for the sake of argument, the rationale is completely irreconcilable. The one, in the first case, it was a judge that said, I had an epiphany last night. God told me that you lose. And the Supreme Court says, you can't do that. Judges can't have epiphanies from God and rule that way. But it's a different type of case. But does the epiphany holding from the Supreme Court abrogate our precedent, or can you say, well, it's the whole, there's epiphany rationale, or do you say, well, no, it was a different type of case, so Supreme Court's got to address that kind of case, or we're going to keep having epiphanies?
I think that would be incredibly hard to defend, I would say, but I actually would look to Vacated, because Vacated pointed to Younger, and it said...
We literally have two stages of the Supreme Court completely making a sea change in Second Amendment law, and you were arguing that precedent that goes clear back to that, and I understand, and I hope Judge Smith will let me finish my question.
Please.
I understand that his position is, or at least you could make the argument that Phillips takes care of all the Heller stuff. So the first of the two stages is, but you have two stages here of very different changes, and to say that doesn't change anything, can you see how people would be like, well, what does the Supreme Court have to do? I guess they have to name cases or judges by name?
No, I think, and I can see your point, I do, and I actually think Vacated recognized that point by not only relying on Younger. It didn't say, oh, Younger, the holding, we're done. It then looked at other gun regulation, other gun restrictions. It looked at other cases from around the country, including Fifth Circuit decisions that did look at the Second Amendment.
Fifth Circuit decision, that actually specifically was the old two-step. The Fifth Circuit decision had applied the two-step balancing test that Bruen got rid of, so that's a problem, isn't it?
Well, no, the Vacated relied on Everest and Emerson, but if you look at those decisions closely, one of them, I believe it was Emerson, excuse me, both have E's, but Emerson, it does talk about tailoring, but it is very clear when it says that felon dispossession is clearly consistent with the Second Amendment as historically understood. So both of those decisions do speak about history in the way that Heller and the way that Bruen call for. And Vangshay, I make the point mainly to say that Vangshay didn't simply say younger, we're done. Vangshay looked at Heller, which of course had its own historical analysis and consideration. It looked at other gun restrictions, other cases from around the country, and it also looked at what modern scholars were thinking at the time. I see that my time is up, but unless the court has any further questions.
Questions, Judge Bail? All right, thank you very much.
Thank you. We ask that the
All right, counsel, Mr. Henderson, you have a little time left.
Thank you, Your Honor. So I want to just start by pushing back on this idea that Vangshay did historical analysis of the way that Bruen required. Vangshay has a brief mention of historical analysis. It doesn't ignore it entirely.
Does it need to?
I mean, it depends on whether you think it has a plain text analysis that excludes it.
Again, as I look at it, there's a two-part analysis. Number one, who's covered? And secondly, in what way? And
all right, I had to, I wanted to pause it. We're going to get back to that, but I had to pause it because I see someone in the chat talking about commoners and the common law. And I'm reading this individual, and he is saying the common law is for the commoner. This guy don't even know what common law is. So I'm going to take just 5 minutes because I see that you're very arrogant and you're just wrong. You're talking about you know the meaning of words. What is the meaning? Tell everybody in the chat, what is the common law? Please define common law for, I'm talking to Osei. Osei, can you see? Osei, can you see? He said that common law is for the commoner. And I'm like, okay, this dude don't know what common law means. So explain to us, he just told us that common law is for the commoner and that we don't know what the commoner means and that you know what words mean and obviously I don't. I'm going to say that you are an idiot and a danger to society because you're walking around in a state of delusion thinking that you know what things mean. And looking at your comments, you a damn fool. I teach this in Switzerland. Nigga, you live in Switzerland. We're in the United States of America. The greatest country on the face of the earth. With a government unlike anybody else's on the planet. Tell us what common law means. Oh, yeah, you're right. I've never professionally worked in Switzerland, just like I've never been a professional like real estate agent because they don't make more money than real estate investors. All right. So I don't know where you're getting this notion that law is the sole province of professionals because it's not. You're a licensed professional because in the public safety is your primary concern. In no way is that a metric or a benchmark to determine competency because you have a license or if you work professionally. Not any kind of way. So tell us, I know what common law means. Tell us what common law means. Tell us what common law means. Don't obfuscate. Tell us. Go look it up. Take your time because I know you're going to look it up wrong. Go ahead and look it up. Oh, you that damn dude to be saying everything with EYE and all that old dumbass shit. I think I remember you and everything. Tell us what common law means. I'll tell you what common law means so you don't know. Common law is judge-made law. Common law is unwritten law. Common law is a body of principles and customs of a people in a specific land. The common law in the United States of America is not the same as the common law in your land or in any other land for that instance. It's the body of case law once facts have appeared and those principles have been applied to those facts have been appeared. When the judge writes the opinion, that's the common law. Another name for it is judge-made law. Now, why don't you take the time to Google judge-made law and you're going to see common law or stare decisis or however you want to say it, res judicata, thing already decided or whatever you want to say. But I'm telling you, I took this time out to embarrass you. Because I can see right there in the chat, you don't know what the fuck the common law is or a commoner. So won't you please just shut the fuck up? because you like a damn fool. Dumbass. I don't need to define commoner. I must do nothing. You talking about you must define commoner. Man, shut up. You sound ridiculous. Let me silence you. I'm gonna silence you because you piss me off, man. I'm sitting here trying to listen to this case, and you in the chat spreading poison, stupidity. All right, let's get back.
You got at least 4 members of the Supreme Court in the majority that say you got at least 4 members of the Supreme Court in the majority that say felons aren't covered. Law-abiding Americans are covered. What's your answer to that?
Again, Bruen lays out how you tell who's covered. You tell who's covered by looking at the plain text. Nobody's looked at the plain text and explained why the plain text excludes anyone who's not law-abiding and responsible. That analysis didn't occur in Heller.
You think law-abiding American is a plain text analysis, and you have to go through the historical analysis to make that determination, right?
Sorry, if you're saying that it's step one and that they are not non-law-abiding, non-responsible people are not covered, what Bruen tells us is that has to be done via the plain text. Does the plain text cover the conduct? I think the answer is very clear in Heller because the who of the plain text is the people.
Well, why then did Justice Kavanaugh, joined by the Chief, say that nothing that they're saying in Bruen is intended to overturn the concept from Heller that felons aren't covered? I mean,
that may express some level of discomfort with where the logic of the majority opinion's going. I understand, but
either one of them, you don't have a majority.
But what the majority actually says is text and history, and whatever discomfort some members of the majority may feel about that, and however they may express that, as long as they've signed on to the majority opinion, the majority says.
Do you think Kavanaugh was saying he thinks mattress label tearing felons are covered when he said that?
I
guess another way of saying it is, do you think he has an idea of? I mean, I guess what I'm struggling with is like when he says I don't think this puts means that the felon exception's gone. Obviously, built into that is some concept of what felon includes, and I don't know. It's hard to read that one sentence as being, oh, that must be like anybody in the legislature, the government's position, which is anybody in the legislature says is a felon.
Swearing on the radio, whatever, right? Yeah, no, I don't imagine that's what he means. I don't know what he means. I don't know how the Heller majority was planning to get to.
What I'm getting at is if a person was to say, if a person was to conclude that nonviolent felons were included under history and tradition, that's not necessarily inconsistent with the idea, with the concurring judges saying that felons are included because some felons could still be included.
Yes, actually, yes. You're right, Your Honor. Yeah, because that would.
The argument today that no felons are included. You're not. In some ways, you're not. In one sense, one important sense, you're not fighting with Kavanaugh and the Chief and others.
Not completely. I suppose I'm not fighting with. If we're getting to what the outer range of felon is, if you're looking at some core set of felonies, maybe.
Your argument, I think, as I understand it, is simply that it doesn't necessarily need to be at the most broadest level of what the fact that they said that doesn't necessarily need to be at the broadest level. Is that accurate?
And if they said that, they didn't get to it. They didn't finish it. So now we just deal with felons, right?
Right now we are dealing with what to do with felons. There's some notion of felons, but as Judge Van Dyke has pointed out, what is a felon?
They always tell us that we're not supposed to anticipate what they're going to do. So where are we on that then?
I would say you are reading the majority opinion for what it says, which is text and history, and doing that text and history analysis, which I believe takes us to nonviolent felons.
Your position is that long-standing prohibitions on possession have to go back to the colonial times.
That what Bruen and Heller say is that it has to be the understanding.
If it was done in 1900, that wouldn't be long-standing.
That is not long-standing for the purposes of the Second Amendment.
Okay. Other questions about my colleague? No. We can talk about this forever, as you know, but in any event, thanks both counsel for your arguments. They've been very helpful. Very well. The case of United States versus Duarte is submitted.
Good morning, and may it please the court. Sonam Henderson for the appellant. Steven Duarte. I plan to reserve 3 minutes for rebuttal. I'll watch my clock. There are approximately 20 million Americans with prior felony convictions, many of whom have committed no violent acts. This is a case about whether the government can, consistent with Bruen, permanently strip gun
Okay. All right. Okay. Now there is another part to this as well. Okay. Another part to it, and that was pretty good. That was just arguments. That's not the banc proceeding. We're going to look at the banc proceeding, and they're in front of an entire panel of judges in this next video. That was the 3-panel judge who was deciding it. Now, I'm just going to say, from listening to that and the argument presented by the prosecutor, I mean, it was a lot of obfuscation and, the federal government, that's what they do. They'll try to push their point across, knowing damn well it's unconstitutional. There's nothing in our common law or in the history of this country that differentiates, people, say, oh, well, you're a convicted felon and forever you can't ever have your gun rights back or anything like that. It's time that this got challenged. I'm very happy this came up because this is a question that a lot of people have been asking because it never made any sense. You saying that, oh, you can make jaywalking a felony and now I'm a convicted felon. You can take my gun rights. To me, it was a scheme because, see, the liberals have always wanted to take guns from people. They want to take guns from people and they want to get guns out of all the citizens' hands. And this was a method of doing it, by using by public servants passing the laws under the pretense of public safety that if you've ever been convicted of any kind of felony that you can no longer have a firearm. It's ridiculous, and everybody knows it's ridiculous. It's ridiculous. And to this, and let me just say this to everyone, because guy let's get with let's talk about common law real quick. Because I hate it when people come into my, you ever listen to people and they just don't know shit and they just think, he's spelling I-E-Y-E and all this kind of stuff, talking about he's a professional and all this lying. I see them all. I've been doing this for 20 years and I immediately know who they are. This get on my nerves, Like, man, we just stop lying, man. You ain't no damn professional. You don't know. So let's look at this word common law real quick. Okay. So right here we have this word commoner. All right, so you can see right here he's talking about commoner. A person who has the right of commoners, centuries-old organizations. British universities, an undergraduate who does not have a scholarship, commoner. Let's look at legal. The legal meaning of commoner is a person who has a property interest in common land, which is land that belongs to an owner, but others have the land to use. Commoners have a right of common or common right to use the land and take certain natural resources from it. Commoners who have rights to a specific common are usually neighbors, not the general public. The term commoner has other meanings as well, including an ordinary person without significant social status, especially someone who is not a member of the nobility or royalty. Commoner, a member of the House of Commons, a common lawyer, a person who shares a right in common. At Oxford and some universities, a student who pays for their own board and other expenses. Now he says this is the term that applies to common law. So let's look at common law real quick. Let's start by judge-made law. Judge-made law, also known as common law, is a body of law that is developed by judges through their decisions and interpretations of existing laws rather than by legislatures. So common law has nothing to do with the legislature. How it works. Judges interpret laws in specific contexts and apply precedents from previous similar cases to decide new cases. The process allows judges to create new laws or interpret existing laws in ways that may differ from the government's intent. Now, I'm going to read to you one of the most famous definitions of common law from Judge, is it Bouvier? Might be Judge Bouvier, because I want y'all to get a thorough understanding. This is, I love this. This is where I studied and got my understanding of common law. Oops. Is this not it? I'm logging into something, y'all. Just give me a quick second, about 2 more minutes. I'll pull up this document for you. I get, these phones, these notifications on these phones, it's like, they getting overboard with these notifications. It's like every time I look around, it's notification. 999. Okay. So I'm going to pull this up for you. Now, this is coming out of my trust book that I have, that I teach from actually on SBC University. So let me pull it up. Can I make this fill the screen? All right, let me put it on the screen for you. Okay. All right. So this is my successful management book of successful management business trust. And this is talking about common law trust, obviously. This is a very, very actually good, it's a very, very good book. But right here, this is where we teach you how to, look up code sections and things of that. And let me get to the common law. Okay. So this Judge Bouvier's famed dictionary, adapted to the Constitution and laws of the United States of America and other several states. Let me blow this up for you. Bigger. All right. Judge Bouvier's famed dictionary, adapted to the Constitution and laws of the United States of America and of the several states of the Union, gives the following definition of common law. Listen closely. Something we need to understand, because a lot of people on the internet talk about common law. They don't know what it means. They don't know it, especially in the sovereign community. He's just dude that was just on here, just another sovereign citizen, finding words in the dictionary and try to make them apply to something. But he did, I guess I will give him a little credit, because ownership of the land did play a very important part of some things. But common law, but that didn't have anything to do with common law. Common law is a system of law, a form of the science of jurisprudence, which has prevailed in England and in the United States of America, in contradistinction to other great systems, such as the Roman or civil law. Those principal usages and rules of action applicable to the government and security of persons and of property, which do not rest for their authority upon any express and positive declaration of the will of the legislature. The body of rules and remedies administered by courts of law, technically so-called. Notice how they say courts of law, they're called courts of law. Notice how Bouvier did that, threw that in there. The body of rules and remedies administered by courts of law, technically so-called. Y'all got to pay attention. They throw you a bone all the time. In contradistinction of those of equity and to the canon law. The law of any country, to denote that which is common to the whole country, and contradistinction to laws and customs of local application. How is that the common law only applies to the commoner? Y'all make any sense? Number two, here's the second sense. The most prominent characteristics which marks this contrast And perhaps the source of this distinction lies in the fact that in the common law, neither the stiff rule of a long antiquity on the one hand, nor on the other hand, the sudden changes of a present arbitrary power are allowed ascendancy, but rather the sanction of a constitutional government. Each of these is set off against the other, so that the will of the people, as it is gathered both from long-established custom and from the expression of the legislative power, gradually forms a system, just because it is the deliberate will of a free people, stable because it is the growth of centuries, progressive because it is amenable to the constant revision of the people. A full idea of the genius of the common law cannot be gathered without a survey of the philosophy of English and American history. I'm always telling y'all, read history. Some of the elements will, however, appear in considering the various narrower senses in which the phrase common law is used. They got a narrower sense, an expansive and narrow sense of the word. Perhaps the most important of the narrower senses is that which it has when perhaps the most important of these narrower senses is that which it has when it is used in contradistinction to statute law, to designate unwritten as distinguished from written law. It is that law which derives its force and authority from the universal consent and immemorable practice of the people. It has never received the sanction of the legislature by an express act, which is the criterion by which it is distinguished from the statute law. When it is spoken of as the lex non scripta, which means law not written, it is meant that it is law not written by authority of law. The statutes are the expression of law in a written form, which form is essential to the statute. The decision of a court which establishes or declares a rule of law may be reduced to writing and published in the reports. But this report is not the law. That's what I was telling you. It's not the law. It is but evidence of the law, because common law is unwritten. It's codes, customs, and everything of the people. It is but a written account of one application of a legal principle, because facts appeared in the case and they applied that legal principle to that set of facts, which principle in the theory of the common law is still unwritten. However artificial this distinction may appear, it is nevertheless of the utmost importance and bears continually the most wholesome results. It is only by the legislative power that law can be bound by phraseology and by forms of expression. The common law eludes such bondage. Its principles are not limited nor hampered by the mere forms in which they may have been expressed, and the reported adjudications declaring such principles are but the instances in which they have been applied. The principles themselves are still unwritten and ready with all the adaptability of truth to meet every new and unexpected case. Hence, it is said that the rules of the common law are flexible. That was beautiful. That was beautiful. Man, let me tell you, that was the most beautiful explanation of the common law that you are going to find. You need to read that and reread that over and over and over again. Especially the dude that was in the chat who didn't have a clue what common law meant. Read that over and over again and get an understanding of common law. Now, what time? How much time I've been flowing, man? Let me see how much time I've been going, because I got to cut these things. I can't be going just two. Oh, I've been going. Damn, I got to cut it off. All right, I'm going to play part 2 probably tonight. It's the part 2 to this, and then I'm going to give my commentary. But I want you to go back. I want y'all to look. I'm going to put the link to our original video in the description where y'all can watch these videos. I want you to watch these videos. I want you, I think this is very important to the security of this country. This decision is a very, very important decision. And also, if you're a convicted felon, and you feel that, and you don't have any violence in your record, you know, you've never hurt anyone or anything like that, why is it that you're being punished? And like you did a white collar crime, you know, you deposited a bogus check in an account, and that was a felony, and now they took your gun rights away? That never has sat well with me, and it never made sense. And obviously, it never sat well or made sense to a lot of other people. And the laws up in New York, because what opened the door for this is what happened with that ruling that happened in New York. And so we get to discuss it. So I I'm sure a lot of you, since 1/3 of all people have been in prison in this country, I'm sure there are a lot of people who are interested in this decision, even though you may feel that it didn't affect you in any kind of way. It affects a lot of people, and that is the demographic, and that is the constituency that I'm speaking to right now, are those individuals. So later on, I'm going to set up the show so we can get it. I got to make some moves right now, but I want you to watch that video over and over and over again and look up the words, understand what an in-bank. We're going to look at the in-bank proceeding next. I think they're going to have a panel of judges. It's going to be like about 15 judges. Like about 15 judges sat in on this. You know it's important. Why is this not more advertised, and why y'all don't know about it is the thing that I want to know. He said, how did a case in the New York open up a precedent? Because the Supreme Court ruled on it. It was a Supreme Court decision. What you mean? It was a Supreme Court decision. It was the Supreme Court. It went to the Supreme Court. That's how it went to the Ninth Circuit. Duh. And it didn't matter if it's a Supreme Court decision. Yeah, it's a lot of, it's an in-bank proceeding we're going to look at next. All right. So with that being said, I got to go for a minute. I've been on here about 3 hours. I'm gonna have to edit and chop this up to reduce it in size, because you know we had that problem, but I will be back. We're gonna go explore this deeper. Do your due diligence. Look up those cases, that Vange case. That's the case that they trying to rely on, but it didn't use that two-prong analysis that the Bruen case used. I've downloaded all these cases. I'm reading them. This is something, if you got a gun conviction, and you know someone who has a gun conviction, or you're currently going through a case where they're trying to place that additional charge on you for a felony in possession of a gun, and you haven't been involved in any type of violence or anything like that, this is why I'm doing this. I'm doing this for you. There's a lot of individuals out there like that. All right? So, once again, it's called in-bank, not banc, in-bank. Or you want to say bank, but it's in-bank. In-bank means a panel of judges. That's exactly right. It's a panel of judges. So we're going to look at the in-bank proceeding next tonight. You can go watch it now, and I'm going to watch it, and then I'm going to give you my analysis. I'm going to watch everything. I'm watching everything the first time with all of you. That's why I watched that video and didn't interrupt. I went and watched it because I just discovered it right before I went live. I'm like, damn, here go the damn hearing right there on YouTube. Hearing on YouTube. So I downloaded it, queued it up on my computer and watched it the first time with you. And it was very interesting, I must say. It's very, very interesting. We're going to watch the in-bank a little bit later after I run a couple of errands. I come back and we're going to get back to it again. So keep it locked. Like, comment, and subscribe. Thank you for all the donations. Peace to the gods. I'll see y'all tonight. Peace.